We'll call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability, 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me today for this meeting are board members Charles Nottingham, Felice Smith, and Darrin Sobin. Together, the four of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask board members to please take a moment to review the agenda, and then we'll need a motion to adopt the agenda.
I'll offer the motion to adopt the agenda for today's meeting.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
Aye.
Any opposed, say nay. Hearing none, the board has adopted the agenda for today's meeting. Before us today are the July 2026 draft meeting minutes, and I ask that you review those, and then we'll also need a motion to consider approval of the meeting minutes.
I'll offer the motion to approve the meeting minutes.
Is there a second?
Second.
Okay, it's been moved and seconded that the board consider the approval of the July 2026 meeting minutes. All in favor, please indicate by saying aye.
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 No, hearing no nays, the board approves the July 2026 meeting minutes. The next item on our agenda is a report from the Office of Open Government. Director Allen, please proceed.
Thank you and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act's requirements, and provided training on those transparency laws. OOG has proudly served as advocates for open and transparent government. I'll start with Open Meetings Act and Freedom of Information Act advice, advisory opinions, dismissal of OMA complaint, Advisory Neighborhood Commission number OOG-2026-0012. On July 13th, I dismissed this complaint, which concerned Advisory Neighborhood Commission meetings for lack of jurisdiction pursuant to 3 DCMR Section 10403.1A. ANC meetings are excluded from the DC Open Meetings Act pursuant to DC Official Code Section 2-5743F, which excludes ANCs from the definition of public bodies subject to the OMA. I advise the complainants that the Advisory Neighborhood Councils Act of 1975 at DC Official Code Section 1-309.01 governs ANC meetings, and the Sunshine Act, DC Official Code Section 1-207.42 provides a private right of action in DC Superior Court. I referred the complainant to the Office of the Attorney General if more information is required concerning the private right of action. A copy of the complaint and dismissal letter are on Dropbox. Next is another OMA opinion, Board of Trustees for District of Columbia International Public Charter School, number OODG-2025-0018. On July 28th, I issued this advisory opinion in response to a complaint which alleged that this DC International Public Charter School Board does not publish the location, including web links of its meetings. I dismissed the complaint pursuant to 3 DCMR Section 10403.1B because I found that the DC International Public Charter School Board did not violate the Open Meetings Act. OOG's investigation did not substantiate the allegation of an unpublished meeting location, including web links. The investigation revealed that the board's complete meeting notices from the date of the OMA complaint and for upcoming meetings were posted on the Public Charter Schools website. A copy of the complaint and advisory opinion are in Dropbox. Informal advice is next. Since the last board meeting, OOG has responded informally via email, telephone, or teleconference to requests for assistance as follows: 7 requests for OMA advice, 9 requests for Freedom of Information Act advice, and 14 requests for assistance, technical assistance with open-dc.gov. Meeting monitoring. OOG staff attends public body meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites, the Office of Open Government Central Meeting Calendar for public meeting notices and records. The Office of Open Government's attorneys provide legal advice on the Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff have attended 15 public body meetings. As a result of the monitoring, 1 corrective measure was communicated. The public body failed to publish a complete meeting notice pursuant to the OMA. Training and outreach. What agencies get wrong, DC FOIA exemptions training. On July 9th, Attorney Advisor Joan Lelma presented this training, the first in OOG's FOIA Officers Summer Webinar Series. The training covered the misapplication of DC FOIA exemptions and their correct application with selected case law. I, along with OOG staff, attended the training. Open Meetings Act training for the Board of Acupuncture, Chiropractic, and Naturopathic Physicians. On July 14th, Attorney Advisor Anthony J. Skirbo facilitated this open meetings training, and it provided an in-depth examination of the application of OMA to public bodies. American Society of Access Professionals, or ASAP, 18th Annual National Training Conference. From July 15th through 16th, ASAP held its 18th Annual National Training Conference in Arlington, Virginia. I, along with Chief Counsel Neal and Attorney Lelma, attended the conference in person. The conference included various learning sessions on the Federal Freedom of Information Act and Privacy Act. Among the sessions were Office of Information Policy and Office of Government Information Services initiatives, Getting Sued, Appeals and Litigation, and FOIA and Privacy Act interface. I was a panelist at the session plenary, the requesters, along with Danielle McGee, Executive Director and General Counsel, Connecticut Freedom of Information Commission, and Lauren Harper, Daniel Ellsberg, Chair, Freedom of the Press Foundation. The panel discussion was moderated by Kirsten Mitchell, Lead of Compliance at the Federal FOIA Ombudsman Office, Office of Government Information Services, National Archives. The panelists provided an overview of their respective offices' functions, addressed the workability of FOIA, and required changes to federal and DC FOIA. OOG team members attended 14 training courses, and a list of the courses, including the details regarding which members attended, is included in Dropbox for your information. FY26 DC FOIA Legislation and Litigation Update Training. On July 16th, Attorney Skirbo presented this training, the second in OOG's FOIA Officer Summer Webinar Series. The training covered legislative action and litigation impacting the DC Freedom of Information Act. Trial attorney Brandon Lewis and paralegal specialist Kim Brown attended the training. Open Meetings Act training for Board of Veterinary Medicine and Board of Optometry. On July 16th, Attorney Skirbo facilitated this OMA training. The training provided an overview of OOG's functions and covered the application of the OMA to public bodies. contracts, procurement, and DC FOIA training. On July 22nd, Attorney Lewis presented the third training in OOG's FOIA Officers Summer webinar series. This training provided an overview of the application of FOIA to contracts and procurement records and focused on the following: procurement documents subject to disclosure, the application of common FOIA exemptions to vendor and contract materials, and best practices for redaction, responding to requests, and ensuring compliance. Attorneys Lelma and Skirbo and paralegal specialist Brown attended the training. Last in training, DC FOIA Appeals, Analysis, and Insight training. On July 30th, Chief Counsel Neal presented this training, the fourth in the FOIA Officer Summer webinar series. The training was offered in person and virtually and discussed DC FOIA Appeals process and the Mayor's Office of Legal Counsel's decisions, particularly the correct application of FOIA exemptions. I, along with OOG staff, attended the training in person. Next in my report is the litigation and legislative update. First is litigation. These federal FOIA cases are instructive to the district concerning the government's obligation to conduct a reasonable search for requested records. The first is the Heritage Foundation et al. Versus the U.S. Department of Justice, case number 24CV-200 in D.C. District Court. This is a federal FOIA case in which the Heritage Foundation brought suit against DOJ. The plaintiffs seek records related to statements made by former Attorney General Merrick Garland regarding U.S. Attorney David Weiss's authority over the Hunter Biden investigation. DOJ denied the request on the basis that plaintiff's request was not reasonably described. As such, the defendant would not be able to fulfill the request. The Heritage Foundation filed an administrative appeal before subsequently filing the instant lawsuit. Subsequent to this, DOJ decided to offer the request its most reasonable interpretation and conducted a search for records reasonably likely to have been made available to the Attorney General in preparation for congressional hearings and public statements. The DOJ released 193 pages to plaintiffs in full, 478 pages in part, and withheld 82 pages in full pursuant to FOIA Exemption 5, Federal Exemption 5, which is deliberative process. The court granted in part and denied without prejudice in part DOJ's motion for summary judgment and held the plaintiff's cross motion in abeyance. The court concluded that the plaintiff's request, which broadly sought all records relied upon the Attorney General and numerous oral statements, failed to reasonably describe specific records because most statements reflected general assertions and institutional knowledge rather than identifiable documents. The court held that DOJ reasonably interpreted the FOIA request and conducted an adequate search for materials likely given to the Attorney General to prepare for congressional hearings and public statements. The draft talking points and proposed responses were properly withheld under FOIA Exemption 5 because they constituted pre-decisional and deliberative materials, making strategic recommendations and internal decision-making. However, the court found DOJ had not sufficiently justified withholding 4 pages of selected congressional hearing transcript excerpts, and the court required supplemental briefing and an updated declaration of those materials. A copy of the court's decision is in Dropbox. The next case is Jeremy Bates versus U.S. Department of Justice, case number 25-CV-1277 in D.C. District Court. This federal FOIA case granted summary judgment to DOJ in an action seeking Office of Legal Counsel opinions addressing whether the president is a fiduciary and owes fiduciary duties to the American people. This is a pro se litigant. In January 2021, plaintiff sued the president in his official capacity for breach of fiduciary duty to the U.S. The trial court dismissed the suit. The Court of Appeals for the Second Circuit affirmed, and the plaintiff petitioned for certiorari to the U.S. Supreme Court. The plaintiff alleged that while the action was pending before the Supreme Court, the Office of Legal Counsel should, quote, have considered whether the president is a fiduciary and whether the president owes a fiduciary duties to the U.S. or the American people. The plaintiff submitted a FOIA request to the Office of Legal Counsel seeking, quote, any Office of Legal Counsel opinion written after January 1st, 2020 that discusses whether the President of the United States is one, a fiduciary, or two, owes a fiduciary duty. The Office of Legal Counsel conducted a search and informed the plaintiff that it was unable to locate any responsive records. The court held that the Office of Legal Counsel conducted an adequate and reasonable search by searching its document archiving and management system using multiple overlapping Boolean search terms and consulting attorneys with subject matter knowledge and institutional memory. The absence of responsive records did not render the search inadequate, and the plaintiff's speculation that additional records might exist or that other locations should have been searched was insufficient to overcome the agency's detailed declarations describing its search methodology. A copy of the court's decision is in Dropbox. Next is legislation. First is legislative action regarding new district data privacy law. I previously reported on this legislative measure on April 27th, 2026, Councilmember Breanne Nadeau introduced Bill 26-0670, the District of Columbia Data Privacy and Protection Act of 2026. This measure establishes comprehensive privacy protections governing the collection, use, sale, and disclosure of individuals' personal data by district government agencies and third parties. It also confers specific rights upon individuals regarding their personal information. The measure further provides for the creation of a Chief Privacy Officer position within the Office of the Chief Technology Officer, or OCTO, to ensure agency-wide compliance and implementation. The Committee on Public Works and Operations held a hearing regarding the measure on June 29th. Witnesses broadly supported comprehensive privacy protections for personal data held by district agencies, but recommended significant revisions. Privacy advocates called for stronger protections for publicly available government records, retroactive data audits, prompt breach recording, stronger enforcement, and an independent chief privacy officer and regulation of data brokers. Industry representative cautions that broad definitions and consent requirements could disrupt government contracting, fraud prevention, identity verification, and federally regulated entities. OAG and OCTO recommended clarifying key terms, preserving records retention and litigation obligations, reconsidering deletion and consent requirements, identifying an independent enforcement agency, and providing OCTO with sufficient authority, staffing, and funding and technology. OAG and OCTO discussed how the bill's proposed individual access, deletion, and opt-out rights would interact with existing DC FOIA procedures, public data practices, records retention requirements, and litigation preservation obligations. A copy of the bill, and the hearing record are in Dropbox. DC Hospitality Amendment Act of 2026, protests concerning alcohol beverage licenses, which is FOIA related. The Committee on Public Works and Operations held a hearing on July 8th regarding this bill that would create a pop-up license category. Under this bill, the Alcoholic Beverage and Cannabis Board must make a licensee's quarterly statements available to anyone protesting the license and to any member of the public who requests them under DC FOIA. This disclosure would allow a protestant to determine the licensee's gross annual receipts. However, quarterly statements would remain subject to the disclosure exemptions in DC Official Code Section 2-534. The lengthy hearing did not produce extended legal discussion of the DC FOIA issue, but the Restaurant Association of Metropolitan Washington opposed this provision on the basis that the statements concern proprietary trade secrets and confidential financial information and should not be available to competitors. The hearing record, which includes the Restaurant Association of Metropolitan Washington testimony, is in Dropbox. Homeland Security Commission Dissolution Amendment Act of 2026 concerning the District of Columbia Fiscal Year 2027 Budget Support Act, the Homeland Security Commission Dissolution Amendment Act of 2026 passed as part of the Budget Support Act. It requires that on October 1st, 2026, the Homeland Security Commission transfer all of its records to the Homeland Security and Emergency Management Agency, or HSEMA. Those records and information shall be destroyed by HSEMA by September 30th, 2027. The legislation also restricts disclosure of commission meeting information to anyone outside of commission members in attendance at the closed meeting. It also restricts commission members, closed meeting attendees, and meeting presenters from disclosing, quote, information presented or opinions formed as a result of the commission meeting in administrative, civil, or criminal proceeding. The legislation also designates all of the commission's records as confidential, and HSEMA and the commission cannot disclose this information due to a subpoena, discovery request, or DC FOIA request. It also prohibits this information from being introduced into evidence at any administrative, civil, or criminal proceeding. However, if information and records could have been obtained through other sources, they may be disclosed. The legislation also provides a narrow category for HSEMA to disclose the information to related agencies. It reads, information and records may be disclosed to HSEMA as necessary to carry out its duties and purposes, to another Homeland Security agency or a Homeland Security Commission if the other agency or commission is governed by confidentiality provisions that afford the same or greater protections. The Office of Open Government will continue to monitor this open government related legislation. Last is administrative FY 2026 budget closeout. OOG is currently coordinating with the Office of the Chief Financial Officer, OCFO, to close out the FY 26 budget and plan for OOG related expenses for FY 27. We are working with the Executive Office of the Mayor through OCFO to reprogram surplus funds from OOG's PS fund to its NPS fund for employee training and to purchase supplies. Last, I would like to say our summer interns are concluding their time with Bega this week. And on behalf of OOG, I would like to congratulate Maurice and IKEA on completing their internships and wish them continued success in their academic pursuits. This concludes the Office of Open Government's August 6, 2026 report. I'm happy to answer any questions the board may have.
Thank you, Director Allen. Are there any questions for Director Allen?
I do. First of all, thank you so much to the interns for your service this summer. Interning at Bega is always something very important because it gave insight into the workings of the district government and its anti-corruption efforts. So I hope you take that away with you after this summer. Just going back to the data privacy law. It almost seems to be a counterbalance to our open government laws. Can you give me an example of the problem that they are trying to solve with this legislation?
Well, as we have requested, there is no privacy statute for the District of Columbia. So this attempts to address that, as well as create a position that is responsible for ensuring data privacy. Currently, it's scattered through the Attorney General in one consumer protection context. But other than that, there is no data protection for the data that the government receives. So this attempts to resolve that problem by creating a framework by which residents can ask about the data that the government has provided to them. Their personal data is what we're looking at and what the government is doing with it. OAG did testify, as I mentioned, that they don't think they should be the ones to enforce it. OCTO also has some concerns about enforcement. So that's something that we may look to speak to Brianne Nadeau about, Councilmember Nadeau about, and looking to this office as possibly a possible location for that position in that role.
Oh, so my next question was going to be, how do we feel about the legislation? And you're suggesting that maybe we can play a role in
Yes,
enforcement mechanism?
at the hearing, it was mentioned that it would be the Inspector General, but I think that our office, since this is in our wheelhouse, may be an appropriate entity to enforce that issue. So that's something I would like the committee to consider.
All right. Well, I'll take a look at it more closely. Thank you.
You're welcome.
Any other questions? Thank you, and all the best to our law students or interns. So next on our agenda is a report from the Director of the Office of Government Ethics, Ashley Cooks. Director Cooks, please proceed.
Good morning, Chairperson Hutcheson, members of the board. I'm Ashley Cooks, Director of the Office of Government Ethics, and I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have 71 matters that are open. Open undocketed matters, we have a grand total of 6. Pending state investigations by status, we have 33 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 2 matters stayed for U.S. District Court case for a grand total of 38. For regulatory matters by status, we have 60 matters that are closed pending collection, 635 matters that are open for a grand total of 695. Again, we currently have 71 open investigations and 5 matters that are stayed. The number of open preliminary and formal investigations includes 16 new matters. The investigative team resolved 18 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. The Board of Ethics and Government Accountability released its quarterly complaint report summary for Q3 of FY 2026, covering the period from April 1st, 2026 to June 30th, 2026. During FY 26 Q3, OGE closed 87 matters. Less than half of the matters, 40 out of the 87, involved allegations that were outside of Bega's jurisdiction. For the 47 closed matters within Bega's jurisdiction, allegations involving rules governing outside employment or activities accounted for 10 matters, while allegations involving conflict of interest accounted for 9 matters, and allegations regarding preferential treatment or lack of impartiality accounted for 7 matters. There were 4 matters involving allegations of public officer private gain, and 3 matters each for allegations of violations regarding the gifts rules, violations of the Local Hatch Act, misuse of government property, and violations of the nepotism rule. 2 matters each stem from allegations that employees failed to put forth an honest effort in the performance of their duties or violated the post-employment rules. A copy of the quarterly report and heat map were placed in the Dropbox. Next is an update on training and outreach. First is professional development trainings attended by staff. Since the last board meeting, Supervisory Attorney Advisor Amber Anderson completed PeopleSoft trainings, Communicate Strategically, MSS, and Principles of Management, MSS. Program Support Assistant Tiana Smith completed PeopleSoft course, Project Management Fundamentals. Senior Attorney Advisor Lynn Tran completed a training entitled Understanding Employment Law 2026. Attorney Advisor Brenda Keels completed Writing You Do Before You Start Writing, or The Benefits of Thinking First, presented by the DC Bar. For trainings conducted by staff, since the last board meeting, OG conducted 5 training sessions. The monthly hashtag training, the monthly brown bag session, 2 new employee orientations, and the quarterly boards and commissions training. In July, 50 district employees completed ethics training using PeopleSoft, and 57 new employees attended new employee orientation and received information on the district's ethics. Next is an update on advisory opinions and advice. First is an update on informal advice. OGE's legal staff provided advice for approximately 28 ethics inquiries, which is 5 less than the 33 reported at the July board meeting. This number does not include responses we have provided to questions regarding the lobbyists and FDS e-filing systems. For an update on formal advisory opinions, since the last board meeting, issued one formal advisory opinion in response to a request entitled Outside Employment with a Third-Party Delivery Business. The opinion addresses whether Alcoholic Beverage and Cannabis Administration ABCA investigators can maintain employment with third-party delivery services such as DoorDash and Uber Eats. I concluded that since investigating and regulating those third-party delivery services is such a large portion of the investigators' work, and recusal would not make the investigators effective in their government work, they were prohibited from working for the third-party delivery service. The opinion is posted on the Bega website, and it was published to the DC Register on July 31st, 2026, with a comment period closing on August 31st, 2026. Next is an update on legislation rulemaking for the financial disclosure statement rulemaking, which is B26-0325, Board of Ethics and Government Accountability Clarification Amendment, which will repeal Bega's authority to designate employees as public financial disclosure statement filers. There is no update. That legislation is still pending. For FY27 Budget Support Act of 2026, on July 7th, the Council approved the Budget Support Act, which amends the lobbyist section of the Ethics Act. Specifically, the amendment will increase lobbyist registration fees by $150 and the late penalty from $100 to $200 per day. Under the new law, general lobbyists will pay $500 and nonprofit lobbyists will pay $250. The amendment removes the exclusion of Saturdays, Sundays from the late filing fee, from the late filing fee time frame. The amendment will require 501c4 organizations to register as lobbyists and submit quarterly activity reports. And lastly, the BSA will transfer funding from the Lobbyist Fund and the Accountability Fund for fiscal years 2027 through 2030. Next is an update on OG administrative matters. There's only one update, and that's to staffing. OGE has 2 attorney advisor vacancies, which we plan to fill in the coming months. Bega welcomed 2 SYEP interns, Arkia Miller and Maurice Hall, 6 weeks ago, and their internship concludes this week. We wish Arkia and Maurice the best in their future endeavors. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.2 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the Financial Conflicts of Interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statements. The deadline to file the financial disclosure statements was May 15th, 2026. We have started the 2026 financial disclosure statement enforcement, and we plan to bring enforcement action against 500 late and non-filers. Next is an update on lobbying registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expense funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the lobbying activity during the previous quarter. In response to the BSA changes to the lobbyist program, we have begun updating the informational and training materials for the lobbyist program and planning outreach and education. We plan to contact all 501c4s that do business within the district to inform them of the change and educate lobbyists of the changes during our quarterly lobbyist trainings. We're also updating all FAQs and other information materials on the website and drafting an update to the regulations that reflect the new timeline, fee schedule, and registrant groups. And last, an update on public investigations. 26-0005F in Refill Mendelson. This is a formal investigation based on allegations that the respondent, chairman of the DC Council, misused government property and resources to oppose a political candidate's declaration of candidacy with the Board of Elections. Thank you. This concludes my report for the Office of Government Ethics. Any questions that you may have?
Thank you, Director Cooks. Are there any questions for Director Cooks?
We have 500 non-filers or late filers.
Correct.
Have we notified them of anything yet?
Well, we always send out notice after the initial filing deadline, and we send notice to them before we actually start the garnishment process.
You mean, so we notified them that they're being fined?
Correct.
We did that already, or we're about to do it?
We're about to do that. The letter will go out next week.
And how much are the fines again?
$300. It's $10 per day per the regulations. So the total fine is $300.
Okay. How does 500 compare with last year?
It's about
Roughly. About the same?
the same. Yes.
Okay. All right. Good luck. We'll start looking forward to the waiver requests as they pour in.
Okay, there are no other questions. The next item on our agenda are public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Are there any comments from the public? Okay. If there are no comments from the public, we'll proceed to the next item on the agenda, and that's our executive/closed session. This next agenda item is a closed session to discuss ongoing confidential investigations pursuant to DC Official Code, Section 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code, Section 2-575B4A, to discuss personnel matters, including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code, Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code, Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code, Section 2-575B2. May I have a motion to enter into executive session?
I'll offer the motion that we enter into executive session.
Okay, is there a second?
Second.
Okay, it's been moved and seconded that the board enter into executive session. All those in favor, please indicate by saying aye.
Aye.
Hearing no opposition, the board members, please move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report out on any matters decided, finish any other business, and adjourn the meeting. Thank you. Negotiate a disposition in matter number 26-0030-P in Ray J. Zollicoffer. The board also approved a new hearing date and scheduling order in the matter 26-0004-F in Ray Cleo Subido. The next board meeting will be held here at the Board of Ethics and Government Accountability, 1030 15th Street Northwest, Suite 700 West, and virtually on September 3rd at 10 a.m. Thank you. The meeting is adjourned.